Just wanted to read Chief Justice Roberts, just a couple of paragraphs, if your lordships don't mind. Para 37, and just the quotation, Mullahs, if I may read.
Yes.
But this court is not a legislature. Whether same-sex marriage is a good idea should be no concern to us. Under the Constitution, judges have power to say what the law is, not what it should be. People who ratified the Constitution authorized courts to exercise neither force nor will, but merely judgment. Although the policy arguments for extending marriage to same-sex couples may be compelling, the legal arguments requiring such an extension are not. The fundamental right to marry does not include the right to make a state change its definition of marriage, and a state's decision to maintain the meaning of marriage that has persisted in every culture throughout human history can then hardly be called irrational. In short, our Constitution does not enact any one theory of marriage. The people of a state are free to expand marriage to include same-sex couples or to retain historic definition.
Partly Holmes's formulation.
Yes, partly. Right. Now, as I was now I'd finished Gaidan. I'm not going to trouble your lordships. You're fully aware of the judgment. Then Obergefell versus Hodges I've done. Furi Mullahs, Furi also. Yes, Furi, it's what's important, Mullahs, para 52, if your lordship don't mind. Page 18, the quoted portion. Has the public had an opportunity to have its say? For the purposes of the present discussion, I assume that the extent to which the public has been consulted would be a relevant factor in determining the appropriate remedy to be ordered. Even making that assumption, the contention by the state and the amici to the effect that the matter is not ripe for determination by this court cannot be sustained. The stark claim that the public has not had an opportunity to engage with the issue is not borne out by the facts. A recent memorandum of SALRC on domestic partnership testifies to prolonged and intensive engagement with the public. The memorandum establishes three things. First, there has been extensive public consultation over a number of years. Secondly, a final SALRC report can be placed before Parliament within a relatively short period. Thirdly, the report can be expected to contain a comprehensive proposal intended to provide appropriate relief, which is in a format quite different from that which the applicants propose. The matter of the relief to which some same-sex couples are entitled would therefore appear to be ready for prompt consideration by Parliament. The orders to be made by this court should be taken account of this fact. This was the extent of consultation, Mullahs. You look at Obergefell, same thing. Look at Fori, same thing. What we are being told now to your lordships is Parliament, don't go to Parliament. Parliament will not do any of this. Please, you do it. It is completely inconsistent with what's happened in other jurisdictions. Para 53. It's important to note that the presence of meaningful public engagement is not the same as public consensus. For if it were, the general value of democratic decision-making would override individual rights, which is what my Lord Justice Bhat said, and it's right. You don't have to have consensus on these issues. This is even more apparent in the judgment of the Constitutional Court of Taiwan, which counts as public engagement over a decade's worth of failed legislative attempts to legalize same-sex marriages. However, that engagement, which manifests as law commission reports, bills in the legislature, referendums, high court decisions, state legislations, is absent in India. Therefore, it is apparent that while there are liberal democracies, such as ours, granting legal recognition to same-sex marriages through judicial decisions, such decisions cannot be imported into India without a reference to societal context. So public engagement goes hand in hand with another approach, form of approach. I know something's wrong here. Countries that have conferred state recognition on same-sex marriages, incrementalism. This necessarily meant steps by the judiciary or the legislature towards the recognition of the rights of same-sex couples, either before or after a declaration of marriage equality. For instance, Mexico City recognized the cohabitation partnership of same-sex couples and their marriage since 2009. At the federal level, Supreme Court of Justice declared as unconstitutional any federal law that considered the purpose of marriage to be procreation. So all that happened. Sodomy, Mullahs, South Africa, and Mullahs, you had Stachwell relating to pension rights, you had Detroit relating to parental rights of permanent same-sex life, and then Fori recognized the equal right of same-sex couples. So this has been incremental. It always has been incremental. On the other hand, Portugal gave same-sex couples the right to marriage through legislation, but has not yet bestowed the right to adopt. Similarly, the Belgian Parliament in 2003 recognized the right of same-sex couples to be legally married, and later in 2006 granted the right of adoption. So there is no set pattern with respect to the route to legislation of same-sex marriages and a conferral of the attendant rights, depending on the issues of federalism, of the relationship between judiciary and the legislature, and of the synergy amongst law, society, and religion. Countries have taken steps that suit their unique circumstances the best, which is why I say that we should not rely upon these foreign judgments at all. So, Mullahs, then I quote the order in Nalsa. Mullahs, your lordship is aware of it. But what's important is what I have said in para 61 at page 21. And I'll leave it. Therefore, instead of limiting its judgment to the reliefs prayed for by the petitioners, I submit that this court needs to address the following issues. Whether the LGBTQI plus community, being a sexual minority in a democracy, I changed the word, Mullahs. Your lordships may change that for me. In a democracy, is entitled to be protected even in the absence of a law, given that their sexual orientation is different from heterosexual persons. The necessity of procedures which recognizes, without conferring the status of marriage, the impediments that come in the way of the LGBT unions. 3, the necessity of administrative procedures, as the government has suggested, and guidelines recognizing that sexual orientation is a physiological phenomenon and the same-sex unions involve intimacy outside the heterosexual world, and that such unions cannot be discriminated against. The above is possible only when the LGBT community is recognized as a sexual minority in tandem with the recognition of transgenders having a separate and unique gender identity, which now has been recognized by law. Once the above is possible only when the LGBT community is recognized as a sexual minority in tandem with the recognition of transgenders having a separate and unique gender identity, which now has been recognized by law. Once the court, through a declaration, recognized the community as a sexual minority having a separate and unique sexual identity, then issues with reference to civil rights, such as adoption, gratuity, surrogacy, can be addressed by government through stratagems which may involve administrative solutions, both within the government and the public sector. Till Parliament addresses the issue of legislation, the government can, through executive actions, consider the recognition of certain rights which are necessary in the fulfillment of the aspirations of the LGBT community. Then, Mullahs, the next part of it, I don't want to deal with because it deals with the Special Marriage Act. I don't think that's necessary, Mullahs. All that I say at the end is, in a way, this moment should be celebrated, that your lordships are at least dealing with the reality of the situation. But that celebration must not result in an overreach. Though it must recognize the reality and set systems in place for the state to move forward. Or without moving forward, Mullahs, many of these people will be discriminated against. How that is to be done, in what manner it is to be done, Mullahs, I think that the government can ponder over it. But as for me, Mullahs, I think that what they've asked for is not a fundamental right. What they must get is something short of it, but something that's meaningful. Thank you very much.
Thank you, Mr.